case challenging Illinois' gun and magazine ban in the Southern District on the merits moving forward, and one of the plaintiff's attorneys estimates that they could have a trial on the merits come July. So what's the latest? Welcome back, Bishop on Air. I'm your host, Greg Bishop. Thanks for hanging out with me each and every weekday morning as we break down what's going on in and around Illinois, and especially a lot of you tuning in just to get the latest in what's happening with Illinois' gun ban. Now, back in January of 2023, the state enacted the gun and magazine ban. Governor J.B. Pritzker signing that. It prohibited the sale of 170 different semi-automatic firearms, from pistols, shotguns, and rifles. It also prohibited the sale of different attachments and magazines over a certain capacity. Plus, it included a registry of those firearms, which we've seen the registration rates in the single percentage when it comes to the total number of firearm owner ID card holders in the state of Illinois. So once it was signed into law, you had a lot of grand pronouncements from those who supported the measure, saying this is going to help combat firearm violence and mass shootings. But as you see the headlines out of Chicago, is it really working? So interesting to delve into that question. We'll save that for another day. But when it comes to the litigation against that gun and magazine ban, you had multiple challenges in the Southern District of Illinois' federal court system. And those were lumped together, consolidated, and you had a preliminary injunction issued back last year. If you remember, late April, Judge Stephen McGlynn issued that preliminary injunction, which was just an initial ask of the plaintiffs to say this law needs to be put on hold while we deal with the merits. And Judge McGlynn agreed the law should be put on hold while they discuss and advance the merits. But then that temporary hold went to the Seventh Circuit Court of Appeals on a preliminary basis, and they said, no, we're not going to allow for an injunction, even temporary. The law is back in place while the merits are dealt with. And then you had several asks of the U.S. Supreme Court to intervene. Some of those new requests still lingering, as the U.S. Supreme Court will make their decision to take those cases or not. But now, with that still out there, not yet addressed, you've got the Southern District of Illinois Judge Stephen McGlynn saying, we're going forward on the merits. We are pushing forward on the merits. Well, they had a status conference in the Southern District on Thursday of last week. We talked briefly about what was the docket entry, spelling out some new timelines. But one thing revealed in the conversation I had with attorney Thomas Maag on Friday was an indication of when we could see this thing go to trial. Here's attorney Thomas Maag representing the Langley plaintiffs in that case.
Well, it was a Zoom hearing. Judge McGlynn, all the parties there, of course. And the bottom line in takeaway is that the parties have until May 10th to disclose their expert report. The expert witnesses have already been disclosed, at least the initial ones. The judge indicated that he has marked off July 8th as the presumptive trial date for this case. He hasn't formally set that in stone, but when a judge says that he's got something marked on his calendar, that's a pretty good indication of what he's thinking. Case is set for status on May 16th to just see where we are with the disclosure of expert reports, whether depositions are going to be needed or not. I don't know that they will be. The state has kind of gone back and forth on whether they want to depose the plaintiff's experts. Either way, it's clear to me we're happy to produce our experts for deposition if the state wants, but it looks like unless the Supreme Court grants certiorari, that will probably be in trial sometime in July.
So again, Judge McGlynn indicating to the litigants during that status conference that he's scheduled in his calendar July 8th to be the beginning of the trial. So Is that an order? Not yet. Wasn't ordered. It was just something he indicated to the litigants that that could be when things start. So next up, you've got the experts, right? So May 10th, they've got to file their list of experts. Maag already filed a list of experts and backgrounds, and I asked him about the significance of those experts, and are they for the entirety of the plaintiffs' groups? Or is it just the Langley plaintiffs? And what kinds of things can we expect why these experts are being used?
Two of the experts listed on my expert report were persons hired by me personally. The remaining experts on my expert report are ones produced by, I'll call it the plaintiff group generally, where we just adopted their experts as well. In the event that somebody drops out of this for some reason or another, that nobody can say that we didn't disclose what could be a potentially useful expert. It's covering your bases, as it were. And the point of experts generally, of course, is there's a lot of, how do I say this, claims, especially made by the state, which are frankly outlandish, saying that, for instance, AR-15s can fire hundreds and hundreds of rounds a minute, which of course is absurd. I mean, even an M16 fully automatic cannot fire that kind of rate of fire without literally melting itself. And that would assume an unlimited magazine capacity, which, of course, doesn't exist. But the real point of these experts is to explain self-defense scenarios, how these firearms are useful for self-defense, mechanically how they function, historical norms, historical examples of how firearms were regulated or not regulated in the past, and generally to try to comport the proofs at trial in accordance with both the Bruin decision, which we think is primarily controlling, and the Seventh Circuit's more recent decision, which we think is a conflict with Bruin, but we've got to comply with both until the Supreme Court tells us otherwise.
So obviously a lot more moving pieces expected in the case challenging Illinois' gun and magazine ban in the Southern District of Illinois. Again, talking with Thomas Maag, had a conversation with him on Friday about that. But that's not the only case Maag has. You heard him get a phone call there. He's a busy guy. He's got several cases in the challenges against gun laws in Illinois. Last year, he filed a case, Myers v. Kelly, where an individual was challenging the state's FOID card. That, as well, is in the Southern District of Illinois federal courts, where a judge, not Stephen McGlynn, a different judge, has spelled out that the end of May, they're going to move forward with discovery in that case. More on that from Thomas Maag.
We'll take it one step at a time. I'm ultimately optimistic. Otherwise, I wouldn't have filed the cases in the first place. But the bottom line is the Southern District is a good place to file these cases. We've got good judges assigned to these cases in the Southern District. And the state will put up a fight, I'm certain. But ultimately, I think we'll have a very good argument.
So again, that's in federal courts, but in state court, he's got a separate case. Piasaw Armory challenging the state's firearm liability law, firearm industry liability law. That doesn't just allow for private lawsuits against the firearms industry, alleging they make the community less safe. It also restricted the types of advertising that firearms industry actors can portray, and things that you can't target, marketing towards children, for instance. You can't have marketing, I guess in a way, characterizing militia activity. This was a law that was passed and enacted last year. It's a law that's being used by the city of Chicago to sue Glock. I believe the residents of Highland Park are suing, is it Smith & Wesson? But you've got this law in the state of Illinois that a lot of people say violates federal law. I think it's called PLACA. Which ultimately says you can't, hold the company liable for how somebody else, totally separate, uses that instrument in the commission of a crime. But regardless, you've got Illinois state law in place being used. And Piasaw Armory sued in state court against that law, but it morphed into a challenge of a different law that the state of Illinois has in place, prohibiting people from suing the state of Illinois, challenging laws on the basis of constitutional rights, or challenging executive orders on the basis of constitutional rights. The law as it is in Illinois, another measure passed and enacted last year, limits individuals to suing only in Sangamon and Cook County, not any of the 100 other counties in the state of Illinois. So Maag's lawsuit challenging the firearm industry liability law and the advertising prohibitions, but it's morphed into this challenge of the state's venue limit law. He talks about the status of where that's at.
Well, the underlying case itself is more of a First Amendment challenge to a statute that prohibits how, I'll say generically, firearms retailers can advertise. And, of course, earlier the state adopted a statute that essentially limits constitutional challenges brought against the state or its actors to only being fought in Sangamon County or Cook County, i.e. Springfield or Chicago. And in order to have standing to challenge the venue statute, you had to file a constitutional claim, such as a First Amendment challenge. Well, logically and practically, the first step in a case is to determine where it's going to be filed. And so the state filed a motion to transfer venue to Springfield. We filed a cross motion for summary judgment to say that the venue statute was unconstitutional. I believe that Judge Foster in Madison County entered an order that correctly dealt with the venue statute in accordance with the law as previously explained by the Illinois Supreme Court, which in turn, on due process grounds, adopted the Matthews test out of the U.S. Supreme Court. I am ultimately optimistic that the venue statute will be declared unconstitutional by the Illinois Supreme Court, because I think it is unconstitutional.
So, Maag obviously confident that the Illinois Supreme Court, where this measure is now being challenged in Illinois, he's confident that they'll find that it's unconstitutional. And Governor J.B. Pritzker last month was asked about the law he enacted limiting venues and a Madison County judge declaring it unconstitutional. Here's what the governor had to say.
Well, first, let's characterize it properly. It's our law in the state of Illinois, and my reaction is it'll obviously run through the court system. I signed it. I think it's something that makes sense for just organizing the court system. So there's a lot of venue shopping going on by people who are just trying to find a friendly judge here or there. The experts that are in the two venues that have been designated seem like they have handled constitutional related cases more than any others, and so it makes sense to me to have those cases run through those.
So
yes.
Governor Pritzker saying it makes sense to him to have it just in Sangamon or Cook County where these constitutional challenges are, essentially saying that those judges in those counties have more experience. I asked Maag about his reaction to that.
I saw the video of him saying that. Without making reference to a particular judge. I did mention that to one of the judges in Sangamon County, and that particular judge just started laughing and said that they didn't particularly enjoy the prospect of having all of the state's constitutional litigation suddenly funneled into Sangamon County. But they'll comply with the law, whatever the law is.
So clearly, a lot going on with Attorney Thomas Maag, and we'll be calling him to get updates all throughout all of these cases.
Well, I think I've taken plenty of your time this morning.
I have taken plenty of his time. So appreciate you guys taking time with me here with Bishop on Air. So hopefully you're up to date. And yes, keep in mind, iGold is Thursday in Springfield, the Illinois Gun Owner Lobby Day. We'll talk about that tomorrow and a couple of other events with the Illinois State Rifle Association. So, of course, like, subscribe, and hit that notification bell, and join me here with Bishop on Air each and every weekday morning.